Good morning, everyone, and welcome to the Cliff Decker Hofmeyer Protecting Your Business During COVID-19 webinar. I have the privilege of moderating this morning's discussion, and I am joined by a number of my fellow directors who will talk you through the relief available to businesses that are negatively impacted or affected by COVID-19. And I'll just go through the speakers and introduce them, and then I will briefly just go through the agenda, and there will be at least 10 minutes towards the end available for questions, and I will select the questions and direct it to the appropriate subject matter expert. And if we don't get to all the questions, do not worry, we will get a printout of all of those, and we can respond separately to those. If I can just run through the speakers this morning, I'll start with the talk on the tax relief measures during COVID-19, and Mark Linnington and Gerard Badenhorst, both directors in our tax and exchange control practice, will address you on that. They will be followed by Roy Barendse on business interruption insurance. Roy is a director in our dispute resolution practice. Roy's talk will be followed by Clem Daniel, who will provide a high-level overview of the relief measures and funding initiatives available from government. After which, Fatima Amir Mia, a director in our technology, media and telecoms practice, will talk about the protection of personal information as well as cybersecurity during COVID-19. And then we are also joined by Adil Patel. He's the head of our employment law practice. And although Adil would not be giving a talk, he will be available to deal with unemployment insurance fund as well as the temporary employer-employee rescue scheme questions later on. Each of the speakers will introduce the next, I will then hand over to Mark Linnington, our first speaker. Mark?
Thank you, Christoph. The tax relief measures are contained in two draft bills, namely the Disaster Management Tax Relief Bill and the Disaster Management Tax Relief Administration Bill. They were released for public comment on the 1st of April, but following the President's address on Tuesday, where the relief measures were significantly expanded, these bills will need to be updated, and they've undertaken to publish them for public comment on the 30th of April. So I'm going to just go through the relief measures. The first one is a partial deferral of tax for taxpayers with gross income under 100 million. Some of the qualifying criteria: there must be tax compliant taxpayers, so no outstanding tax, and they must be up to date with their submission of tax returns. And the 100 million must be tested for the year of assessment, which ends between March 2020 and March 2021. And the gross income must not include more than 10% of passive income, which comprises of interest income, dividends, and rent. So the first deferral is in relation to employees' tax. For April 2020 to July 2020, which is 4 months, the taxpayer can defer the payment of 35% of the employer's tax with no penalties or interest. That 35% must be paid over 6 months, the first installment only kicking in on the 7th of September 2020, and the last installment on 7th of Feb 2021. There's a further requirement that the taxpayer must have been registered as an employer with SARS on the 1st of March 2020. Then the second deferral is in relation to provisional tax. For the first and second provisional tax periods that end between March 2020 and March 2021, the taxpayer can defer 35% of the provisional tax. And it manifests in the first and second as follows. In the first provisional, they only have to pay 15% of the estimated tax. Normally it's 50%. And in the second provisional, they only have to pay 65%, not 100%. The tax that they defer has to be paid by the time the third provisional tax payment is due. Although for micro businesses, they only have to pay that 35% when they are actually assessed. Then for taxpayers with gross income in excess of 100 million, it was announced on Tuesday that where they are materially impacted by COVID-19, they can apply to SARS to delay tax payments without penalties. They didn't mention interest, so presumably interest would still be payable. The small businesses can also apply for additional tax relief beyond the 35% deferrals. Okay, the next relief measure relates to skills development levy. The skills development levy is 1% of the total payroll. The relief measure is that for May 2020 to August 2020, also 4 months, no SDL will be payable. The next measure relates to excise on alcohol and tobacco, which is normally payable when the alcohol or tobacco is manufactured and not when it is actually sold. So there's a bit of a timing disadvantage because obviously they can't sell these products right now. So for May 2020 and June 2020, 2 months, the producers of tobacco and alcohol can defer the excise tax for 90 days. One just hopes that this does not mean that the bottle stores will only open in July. Okay, the next measure relates to carbon tax. The first filing and payment date for carbon tax is going to be 31st of July 2020. They've pushed this out and it's now only going to be 31 October 2020. Then ETI, which is an employment tax incentive. This is a wage subsidy. It doesn't apply to all businesses. It's only those businesses in special economic zones. It was aimed at the employment of young work seekers, and that is work seekers between the ages of 18 and 29 who earn less than 6,500 Rand per month. For April 2020 to July 2020, 4 months, firstly, the maximum age of qualifying employees is increased from 29 to 65. and the amount of the wage subsidy is increased by 750 Rand per employee. The next measure relates to donations to the Solidarity Fund. The Solidarity Fund is registered as a public benefit organization. There are two categories. There's sort of the better category, which means if you make donations to the fund, then you get a tax deduction for your donation. There is currently a limit on how much you can claim for tax, however. It's limited to 10% of your taxable income. Any excess you carry over to the next year and you can claim it in the next year. They're increasing the 10% to 20% for donations to the Solidarity Fund for a limited period. We don't know what that limited period is. We'll get details in the next week or so. And you would have seen that some executives of public companies have donated 30% of their salaries to the Solidarity Fund. And in response, when calculating the employee's tax to be withheld, employers can deduct donations to the Solidarity Fund of up to 33.3% of an employee's remuneration. So this means that for those executives who donated 30% of their remuneration, they will have to pay tax when they submit their tax returns, because they would have had 30% wouldn't have been subject to employees' tax, but when they submit their tax returns, they can only claim 20%. That means there's a shortfall they'll have to pay on assessment. And that shortfall can be carried over to the following year of assessment. Okay, then another relief that was announced on Tuesday is the postponement of certain budget proposals made earlier this year. The first one was quite a concerning and wide-sweeping proposal. It was that interest deductions would be limited to 30% of EBITDA. The second one was that the utilization of assessed losses will be limited to 80% of taxable income. So, you know, if a company is trading out of a bad patch and is now becoming profitable but has tax losses brought forward, they're still going to have a tax bill to the extent of 20% of their taxable income. Both these measures have been deferred. They were supposed to kick in from 1st of January 2021. Now the new date is 1st of January 2022. I just want to make some related observations around the tax treatment of debt. There are currently limitations on the interest deductibility in certain circumstances where a debt push-down structure was implemented, or a company acquires at least 70% of the shares in another company. This is particularly relevant for private equity funds. The maximum deduction is calculated using a formula in section 23M, which changes with the changes in the repo rate. So after the recent reductions in the repo rate by 2%, the allowable percentage has dropped from 41% to 33%. So just bear that in mind when you calculate your provisional tax obligations. Then, if businesses need to resort to debt restructuring, either debt to third parties or to shareholders, or debt between group companies, there could be material tax consequences depending on how you implement such restructuring. The tax rules dealing with distressed debts have been considerably reworked in recent years and are generally less punitive than they were, say, 5 years ago. There could, however, still be pitfalls if you structure it incorrectly. For example, you could trigger significant tax recoupments if you waive loans between group companies, whereas these recoupments could be avoided entirely if you instead capitalize the loans into ordinary shares. There are other requirements, but that's generally the position. So it's quite important to consider the tax effects if you need to resort to restructuring your debt. Then lastly, in relation to the tax reliefs, there will be an extension of time periods. So certain time periods prescribed in the tax acts will be relaxed, as the lockdown period will be regarded as dies non, which is a Latin term for days that have no legal effect and will not be counted. For example, if you're undergoing an audit process with SARS, if there are warrants of search and seizure, if prescription is about to manifest in respect of certain years of assessment, if there are dispute resolution processes in progress, objection and appeal processes, the lockdown days won't be taken into account. It's important to note here, however, that this relief does not extend to time periods for filing tax returns or making tax payments. So you need to comply with those requirements, and yeah. So that concludes what I wanted to discuss. I'm going to hand over to Gerard Badenhorst, who's going to deal with the VAT measures. Thank you.
Thank you, Mark. Before I deal with the VAT measures, I just want to reiterate that this is a general information seminar, and nothing that is said here should be construed to be the specific legal advice because of all the underlying circumstances that may impact such legal advice. From a VAT perspective, there's been very limited measures that's been introduced specifically relating to VAT. But I just want to deal with 4 specific measures in this regard. And the first one is with regard to the exportation of goods. Now, in terms of interpretation note 30 that deals with direct exports and the export regulations that governs indirect exports, provide that the goods that are exported must be exported within a period of 90 days from the date of the issue of an invoice in respect of those export sales for the sale to be subject to VAT at the rate of 0%. These documents also stipulate that if the export is delayed due to circumstances beyond the control of the exporter, then the exporter must apply for an extension for the export period. But SARS has issued on the 26th of March a binding general ruling number 52, in which it stipulates that the current delays that exporters experience are considered and recognized as being beyond the control of the exporter, and they've allowed, in terms of this binding general ruling, an additional 3 months to export the goods in order to qualify for the 0 rate. The second aspect deals with the importation of goods. We already have in our VAT legislation, as well as in the Customs Act, a specific exemption provision for the importation of goods for the relief of persons in the case of a human national disaster. Now, this is specifically under item 412.11, And the exemption provides for the exemption, or the provision rather provides for the exemption of the importation of goods from VAT and customs duty, but provided the importer holds a certificate or import permit in this regard from the International Trade Administration Commission, or ITAC. Now, ITAC has issued a blanket certificate or import permit in this regard that applies to all importation of essential goods. Now, these are the goods that are listed in Annexure B of the Disaster Management Act, if those goods are also exempt from customs duty. In other words, if they are duty-free, then under the blanket ITAC certificate, the essential goods can then be imported exempt from VAT as well. But if the goods are also subject to customs duty, then the importer must apply for a specific ITAC import permit. Now, ITAC has indicated that they will only issue an import permit for goods that are also dutiable if the goods are critical goods. Now, these are generally medical goods as well as personal protective equipment. But if the goods are then imported under an ITAC certificate, then of course the exemption from VAT and customs duty will both apply. The blanket ITAC certificate is available on the SARS website, and ITAC has published on their website the application form for a specific ITAC import permit, as well as a list of critical goods that will qualify for the customs duty exemption as well as the VAT exemption. The third issue deals with the situation in which many businesses, and particularly small businesses, find themselves in. And that is that they don't have access to their systems, or they don't have accurate information, or they rely on third parties to provide information to enable them to complete their VAT returns and to determine accurately the amount of VAT that is payable. In these circumstances, the VAT legislation, specifically Section 38(1), provides that a vendor is obliged to determine accurately the amount of VAT that is payable, and that such payment must be made within the prescribed time periods allowed for in the VAT Act. But Section 38(2) provides that where the Commissioner is satisfied that as due to circumstances beyond the control of the vendor is unable to accurately determine the amount of VAT payable, then the Commissioner has a discretion to accept a provisional payment in respect of the VAT amount due, subject to the conditions that the Commissioner may impose in this regard. Now, we have approached SARS to provide guidance as to what is the process that needs to be followed if vendors want to avail themselves of the relief in terms of Section 38 to make a provisional payment. The indications up till now is unfortunately that it seems that SARS is unwilling to exercise their discretion in this regard. But we have seen this morning that they said that hopefully during the course of today that they will provide some guidance or at least a statement in this regard to vendors that want to avail themselves of the provisional payment. The last aspect is with regard to VAT refunds. The President has announced as part of the latest tax relief measures that they are looking to accelerate VAT refunds. But when we got this information from National Treasury and SARS with regard to the process in respect of the accelerated VAT refunds, it seems that it's only in respect of vendors who are currently registered to submit their returns on a bi-monthly basis that are also in a refund position, that these vendors will be able or will be allowed to submit their returns on a monthly basis in order to speed up their VAT returns in that manner. So it's really just in respect of vendors that are registered for VAT on a bi-monthly basis to which this acceleration of the VAT refunds will apply. Well, that brings me then to the end of the VAT relief measures. And I'm now handing over to my colleague Roy Borenser, who will deal with the business interruption insurance aspects.
Hello, everybody. This is also intended to just be a high-level overview of how the COVID-19 pandemic and the resultant national lockdown impacts business interruption insurance. Industries directly affected thereby include manufacturing and retail, leisure and hospitality, tourism, legal and financial services, the entertainment, and also the gig economy, just to name a few. So what is business interruption insurance? Typically, a commercial insurance contract will cover for certain defined insured events or occurrences, or will provide cover for such defined events or occurrences. So a business will insure its business operations, and these business operations are normally very clearly defined in your insurance policy wording. A typical business insurance policy will offer cover under various sections, and I will name a few of these sections. Typically, it would extend or provide cover for losses or losses arising from fire. There's a section typically called buildings combined. You will have a section covering office equipment and contents, theft, money, business all risks, goods in transit. Business interruption is then normally where it is included. It will be one of your sections of cover. When looking at your insurance policy wording, it is very important to look at what interests and property are actually insured. It is equally important to have regard to the specific risks or events which are insured against. These risks or events are also very clearly defined in your policy wording. A typical contract of insurance will insure against the damage or destruction or loss of property, and it will indemnify the insured for the costs of replacement or repair. The property insured is also always clearly defined. So when does business interruption insurance kick in? I'll just refer to business interruption as BI from here onwards. BI insurance kicks in when an event insured against results into the interruption of or interference with the business of the insured. And this is why it is so important to first look at what events you actually are covered against. Now, as mentioned earlier, insurance normally relates to material damage to physical or tangible property. Now, where this occurs, it can in turn result into an interruption of or interference with the business insured. An obvious example would be where a factory burns down, and for a given period of time, it will not be able to function normally. All insurance contracts will, in its policy wording, normally include a number of exceptions. And these exceptions will cover or clearly list those risks or events which are not insured against. Importantly, many policies will contain extensions of cover. An extension of cover has the effect of extending cover to an event which is otherwise expressly excluded under your exceptions, or which is an event not covered by the rest of your policy wording. An example of this would be where a manufacturing business takes out business all risk, or operations all risk insurance, and has cover for its own business premises, but where by way of an extension, the insurer offers to cover damage to the premises of a supplier of the manufacturer. Now you may be asking yourselves at this point, where and how does COVID-19 fit into all of this? Because it certainly does not involve the physical damage to or the destruction of any property. And it is for this reason that one needs to look very carefully at normally at your entire body of wording, but more particularly in these times, to go and have a close look at your extensions, particularly under your BI insurance section of your policy. In some instances, under your extensions, you find that cover is provided for losses arising from the interruption of or interference with your business as a result of an outbreak of infectious disease, or what is commonly also included, or it is commonly referred to in policy wordings as a notifiable disease, occurring within a certain radius of the insured business. A notifiable disease is normally defined in a policy as a disease which has to be reported to authorities. In all instances where I have encountered BI cover that will provide some form of relief in instances of the present, in other words, where infectious diseases or notifiable diseases present, I found them under the extensions under your BI cover. Your cover in these instances will also invariably be limited to a certain amount. Now, BI insurance is aimed at making up for the loss arising from a reduction in turnover or your gross profit, and it will normally cover you for extra cost of working which was incurred. And that's how it's typically worded. It's normally referred to extra cost of working. Now, the quantification of BI losses is beyond the scope of this discussion, but it should be borne in mind that gross profit in insurance terms differs from gross profit in accounting terms. In insurance terms, the gross profit is normally your turnover plus closing stock minus opening stock and uninsured costs. It is always important to be mindful of your duty as an insured to exercise reasonable care and to take reasonable steps to prevent or mitigate losses. This obviously goes beyond just BI insurance, even from a liability insurance point of view, given that people will be returning to their places of employment going forward. there is this potential for liability claims against employers where people are infected on the business premises. But even in your setting of BI interruption, you will obviously be required to take whatever steps a reasonable person would have taken in order to either avoid your losses or to minimize those losses. I just want to make a few closing remarks from here on. We expect to see a flooding of claims upon insurers post the national lockdown period, because as we all know, many businesses were effectively prevented from operating at all or operating normally. A development of concern, and I've seen this particularly in the hotel, leisure and tourism space, is the recent trend by some reinsurers to cancel cover for any losses, including BI losses arising from COVID-19. Some of you would have seen an article over the previous weekend, I think on Sunday in the Sunday Times, there was reference to certain insurers giving notice to insureds that cover is from 30 days of the date of notice, insofar as COVID-19 losses arising from COVID-19, that cover will be revoked. That will obviously present quite an interesting challenge, because in my view, all losses that were triggered up to that point will have to be covered. You cannot void insurance after the risk insured against already manifested. Now, these claims processes are invariably quite challenging. Even where cover exists, resolving these claims will be rather challenging, and in some respects, the end of the lockdown period will, when it eventually happens, will really mark the dawn of new challenges which all of you will be facing, and I wish you well in that regard. This is all that I have to say. I will now hand you over to the next speaker, who is Clem Daniel.
Thank you very much, Roy. Very useful, very informative. My part of this talk is really to talk about the landscape of the relief provisions. If you look at government's COVID-19 health response, it's actually been carried out with remarkable speed, I think, determination and courage. And when we start to look at the landscape of the overall relief provisions and how government is approaching it, you start to see something similar emerging. You see speed, you see determination, you see courage, and you see breadth. A lot of what has happened has crystallized, but we are very much in a state of flux at the moment still. There's a lot we don't know. There's a lot that is emerging and developing and evolving as we're going along. On the CDH end, when we started to look at the information that was available and coming through, and it's been a veritable flood of information, but the databases that were available publicly weren't really, didn't really make a great deal of sense in terms of the structure of the information and trying to understand what it meant from particular functional areas. So we started building our own database around that, and as you'll appreciate, it's still very much a work in progress because there's a lot we don't know. As I said, some things are crystallized, a lot of things are still very unclear. In the process of building that database, we also started trying to identify on a comprehensive basis what all the relief areas are that people can look to. Now, obviously, in a discussion like this, we can't go into the detail of it simply because there is so much. So what I'm going to try to do is just walk through a couple of high-level selected areas to give you a sense of the landscape and what we are seeing developing. What I'm not going to touch upon is the UIF and temporary employer-employee relief schemes. I'm not going to touch on COIDA, the Compensation for Occupational Injuries and Diseases Act, what's happening there, tax, competition, all the informal sector, the spas, shops and so forth. Now, if we have a look at matters and we look at the sort of banking sector, you see that the Prudential Authority, which is a division of the South African Reserve Bank, has already taken steps to make it possible for loan restructuring to occur, for banks to restructure loans in certain manners. And this relates to retail loans and corporate loans, and these are defined under Regulation 23 to the bank's regulations. The banks are required to assess each restructure application, and they need to motivate every instance where a restructure is made due to COVID-19 related factors. There's an old directive of 2015 that says where a borrower seeks to restructure in order to avoid breaching loan covenants, that should be treated as an instance of financial distress. A recent directive of 2020 related to COVID-19 relaxes that rule, where the reason for seeking to restructure is due to COVID-19. When considering whether to agree to restructure a loan, the banks are required to consider whether the loan was in good standing at the end of February this year, and whether it will still remain in good standing after a relief period of 6 months. If both of these tests are met, then the situation is not regarded as financial distress, and the loan and the restructuring of the loan is not treated as a distressed restructure. What this means is that the banks have more flexibility to restructure lending arrangements without having to adjust their own reserves in terms of the requirements with the Prudential Authority. So that's the one aspect. Another aspect is that there has been a change to the liquidity ratios that the banks are required to hold, and the liquidity cover ratio was typically 100%, and that's now been reduced to 80%. This frees up funds for lending that the banks would otherwise have had to keep hold in reserve. There's then also what is referred to as the Pillar 2A buffer, which is a capital buffer that banks need to hold, and this is usually at 1% of risk-weighted assets, and this has been lowered to 0% at the moment to alleviate the distress. The cumulative effect of the liquidity cover ratio and pillar buffer changes, the foregoing, is to make available approximately a sum of 540 billion. This is what we are told. So it's not insignificant. In addition to that, you will have seen in the news that the Reserve Bank has lowered the repo rate to also help. We're also informed by the President in his most recent speech that the Reserve Bank will be introducing a loan guarantee scheme for organizations with a turnover of 300 million or less. It's anticipated that this will help approximately 700,000 firms and 3 million employees. We don't have details of that yet, but when you take that together with what has already been done in the banking sector, the numbers start to become quite significant. Then, of course, there's still the 500 billion support package, which is being raised with the IMF and with the BRICS Development Bank and so forth, details of which we don't have yet. We know that South Africa has drawing rights of approximately 80 million rand with the IMF, 80 billion, sorry. So these things are all quite significant. If we turn away from the banking sector as such, and we then look at the Department of Trade and Industry, there is 500 million made available for trade finance by the Department of Trade and Industry for medical supplies, and 700 million for working capital and machinery. There's tourism sector working capital, and there's also bridging finance to avoid supply chain interruptions. There's working capital to suppliers of primary energy. There's working capital and bridging finance to SMEs who provide components to car manufacturing. Over and above all of that, We are told by DTI that an additional 3 billion package will be available in the next quarter to support businesses. Again, we don't have a great deal of detail around that. We don't know how it's going to be applied. But it's clear that there are quite significant numbers starting to emerge, and that there is a lot of flexibility around that as we move forward. In the Department of Small Business Development, I think most people are aware of this already. There is a facility that's intended for SMMEs that are taking advantage of supply opportunities in the COVID-19 pandemic space. The requirements are that they must be 100% owned, and the staff must be at least 70% South Africans. We haven't gone into the detail of that because it's specifically COVID-19 related. There's also a debt relief scheme from the Department of Trade and Industry for SMMEs. This has been in the news, and I'm sure people are aware of this generally, but the debt relief scheme has requirements around it that the company must be 100% South African owned, staff complement must be at least 70% South African citizens, must be SARS and UIF compliant, and there must be proof of negative effects of COVID-19 on the business. The National Empowerment Fund is also giving out 200 million of loans at 0% interest in the first year and 2.5% per annum with a 5-year term. This is designed to help black entrepreneurs manufacture medical products, and it relates to working capital and machinery primarily. The requirements are that you must be in good standing with SARS. There's a 50% black shareholding and managerial control requirement. So that is available from the National Empowerment Fund. There have been extensions to deadlines in various places as well by various departments. Forestry, Fisheries and Environments has extended certain deadlines for the submission of environmental audit reports. It's extended authorizations for the exportation of waste tyres and for the submission of national atmospheric emission reports. There are extensions as well by the Department of Transport. These relate to the validity of operator and public transport licenses that would otherwise expire during the lockdown period. This includes tourist transport services. At a very personal level, learners or driver's licenses of individual car owners like us, we have an extension of our licenses and our vehicle discs for the lockdown period and for 30 days afterwards. So there's a grace period there. Interestingly, Home Affairs has also very logically extended expired visas of persons who are present in South Africa. So that issue is addressed as well. Financial Sector Conduct Authority has also been taking steps to address issues in its area, and continuous professional development of phase compliant individuals. There has been an extension of the deadlines for compliance around that for the annual cycles. In terms of the Financial Markets Act, there has also been an extension for regulated entities such as security depositories, authorized users, and so forth, in respect of their audited annual financial statements. The deadline of 31 March for those with the financial year of 31 December has been moved to the end of May, and the 31 January deadline for those whose financial year ends 31 January has been moved to the end of June. We will have to see whether there are any further extensions around that in due course. In terms of the JSE listing requirements, there have been extensions as well for the provision of annual financial statements, notices of AGMs, and submission of annual financial statements. The extension has been by 2 months for companies whose financial year ends 31 December, 31 January, 29 February, and 31 March. So that's as far as the JSE and the listing requirements are concerned. ICASA has also taken steps to grant relief to certain people. Licensees are exempt from the responsibility to resolve complaints within certain timelines. You may be aware that the applicable standard it has been changed to what is referred to as a reasonable time. The requirement to submit logs quarterly has been suspended until 14 days after the lockdown. The requirement to submit hard copies of applications by new applicants or current licensees has been suspended. Type approval application fees have been waived. Licensees can also apply to ICASA to dispense with the usual application procedure in respect of temporary radio frequency spectrum. There are also, the state has also put in place certain emergency procurement procedures. This comes from National Treasury, and this relates to transversal contracts that are applicable to goods and services that are required by multiple state institutions. Essentially, state institutions that are not participants in the transversal contracts who wish to participate may now do so without the approval of National Treasury. Normally such approval would be required. Also the regulations provide that the items in respect of which no transversal contracts are in place, that National Treasury has made alternative arrangements and requested specific suppliers to provide quotations, and that state departments may procure these items at the listed prices. And furthermore, where a state department's peculiar needs in relation to COVID-19 are in respect of items which are not provided for already by National Treasury, then the relevant accounting officers may procure these elsewhere without having to follow competitive bidding processes. So some quite interesting items there. If we look in the agriculture environment, the Department of Agriculture has set aside 1.2 billion, of which 800 million is earmarked for financially distressed small-scale farmers. It's designed to assist livestock farmers with feed and medication, vegetable farmers with seed and fertilizer, and it's targeted at farmers with a turnover of between 20,000 and 1 million. There are requirements around it that you must be registered on the farm register, and a number of other issues which I won't go into. It does exclude funding for mechanization and infrastructure costs. The Department of Rural Development and Land Reform has also taken a number of steps to facilitate the continuity in the export of strategic commodities. They've reached an agreement with Japan in respect of citrus products, and they are talking at the moment to South Korea, Taiwan, and the USA in respect of other fruits. There are really two categories to which this relates. The first is communal farmers and smallhold farmers, and then there's also commercial farmers who are existing land bank development clients. For small-scale farmers, the maximum allocation is 500,000. And then for the bigger commercial farmers, it's 2 million rand. There are a number of exclusions in this area as well, which I'm not going to go into in detail. If we look at the President's speech of the 21st of April, there are a number of points that come out of that, some of which I've alluded to already, where we don't have a great deal of detail. But we know that there's 100 billion that's going to be set aside to protect and create jobs. And I think Mark's already touched on it, a 4-month holiday for the skills development levy. We are still waiting for details of the third phase economic package from the state and how this is going to play out. So there's a lot that's unknown there at this point in time. Turning then to sort of public initiatives, the Solidarity Fund we know is now 2.2 billion. We don't have details around how the Solidarity Fund is going to be applied, but we know, amongst other things, it's going to be used to support those whose lives have been disrupted by the pandemic, and it's going to be used to provide care for those in hospital or medical care. Now, this is obviously not necessarily directly related to business entities, but it is related to the employees and so forth. There are also a number of private initiatives. You'll be aware of Johan Rupert's Sakuma Trust, which has already been maxed out. Then there is the Oppenheimers have set up the South Africa Future Trust, which is designed to provide soft loans at the rate of 750 per week per permanent employee for up to 15 weeks in the form of a loan at prime minus 5%. There are a number of requirements around that, including that your annual turnover must be less than 25 million. Moving down then, we look at SAPOA. I think a lot of people are aware that SAPOA has been interacting with its members and with retail tenants and so forth to try and provide some degree of relief for SMME retail tenants in particular. They have put out a press release around that, but the application of it is obviously the SAPOA members have a significant degree of autonomy about how to apply the relief measures on a case-by-case basis. We're also aware that the property industry group has also taken steps to provide for relief for retail tenants. We understand that there's a fund of between 2 billion and 3 billion that is being put in place there. We don't have a great deal of details around it yet, but we know that there are requirements that you must have a turnover of less than 80 million and you must have been in good standing on the 29th of February. That, I think, is really the landscape outside of the areas that I mentioned earlier that we excluded. That sort of gives you an overall sense of what is happening at this point in time and what we know and understand right now. There's a lot that is still going to crystallize over the next few weeks, and it is likely that we will keep updating this, and we may have another webinar, a series of webinars around these various issues as more and more crystallization develops and as we understand more and we're able to provide more detail on the subject. And I think I'm now going to hand over to the next speaker.
Thank you, Clem. Good morning. Today I'm going to be speaking on privacy and the data protection implications of COVID-19 on businesses and individuals. In order to mitigate the spread of COVID-19 in South Africa, both public and private organizations have and will be required to implement data sharing strategies and procedures in respect of COVID-19 related personal information. So what does that mean for business? Well, South African organizations are now going to have to take into account the provisions of the Protection of Personal Information Act, or POPI as we like to call it, which although is not yet fully in force with regards to how they will lawfully process COVID-19 related personal information. POPI provides the legal basis on which personal information may be processed. The best solution for a business is to obtain a person's consent, and given the sensitive nature of the information process, which is health data, to take necessary steps to ensure that the personal information is safeguarded and kept secure, is not used for any other unrelated purpose, and also is not retained for longer than is necessary. Where it's not practical or possible to obtain consent, the processing would need to fall within one of the other recognized lawful grounds. Organizations who are required to process COVID-19 related personal information could also potentially rely on the general authorization that the processing of such health data or personal information is necessary for the establishment, exercise, or defense of a right or obligation in law, provided that the organization in question can show that the processing took place in accordance with a specific law. So in this regard, the information regulator, who is established in terms of POPI, has recently issued a guidance note on the processing of personal information of data subjects in relation to the management and containment of COVID-19. Now, here it's also worth noting that the regulator had previously requested the President to declare that the remaining provisions of POPI come into force on the 1st of April 2020. However, and not surprisingly, given the national state of the disaster, the President did not adhere to this request. So in the guidance note, the regulator confirms that not all of the provisions of POPI are in force, but encourages companies and the public nonetheless to proactively comply with the provisions of POPI. So the regulator is clearly of the view that companies should commence their POPI compliance initiatives despite the President not proclaiming the commencement date of POPI. The guidance note also addresses the issue of the provision of location-based data by electronic communication service providers, which are essentially your mobile network operators, to the government in order to track data subjects in the management of COVID-19. Now, typically, an individual would need to consent to geolocation tracking when using an app, and consent would be the basis for the processing of such personal information. However, the information regulator has now confirmed that electronic communication service providers can provide such location-based data to the government to track data subjects for purposes of managing the spread of COVID-19 based on the exceptions under POPI, and that a data subject's consent is not required under these circumstances. So let's discuss these contact tracing regulations in a little bit more detail, because they raise a number of quite complex privacy issues. Now, as part of the measures to combat the management and the spread of COVID-19, the government has published regulations under the Disaster Management Act, which allow for contact tracing of persons who are either known or reasonably suspected to have come into contact with any person who is known or reasonably suspected to have contracted COVID-19. I'll refer to these as affected persons. Now, as part of these measures, the Department of Health is empowered to develop and maintain a national database of such affected persons, which includes collecting various personal and special personal information about them. So what type of information is included in this database? The regs say that the database will include all information which is considered necessary for the contact tracing process to be effective. So this will include things like names, ID numbers, addresses, cell phone numbers, and the COVID-19 test results for all persons who have been tested for COVID-19. In addition, the database will also contain the details of all persons who are known or suspected to have come into contact with any person who was tested positive for COVID-19. So this information, which includes highly sensitive medical information, is to be obtained and provided to the Director General of Health for inclusion into the COVID-19 database by the person who takes the sample for purposes of testing of COVID-19. The regs also include the power to direct electronic communication service providers, which are your mobile network operators, to provide geolocation data of such affected persons for purposes of contact tracing. Now, where this comes from is that globally experts have emphasized that the ability to trace persons who have been in contact with people who have tested positive for COVID-19 is critical to arresting the spread of the virus. So these track and trace mechanisms have been endorsed by the World Health Organization and are currently being deployed in various countries across the world as part of the measures to flatten the curve. So what about our rights to privacy? Well, one of the first things which come to mind is that the state will be spying on us. This must also be viewed against the backdrop of surveillance laws, such as the Regulation of Interception of Communications Act, or RICA, which was recently declared unconstitutional. Well, some sections were declared unconstitutional recently by the High Court because the Act did not meet the legitimate objectives of lawful surveillance while still respecting a citizen's right to privacy. So it must be noted that the regulations here are very specific and do not provide the state with overarching powers. There are specifically safeguards put in place in the legislation which aim to strike a balance between the right to privacy on the one hand and the purpose of the regulations on the other and powers of the state. So from a privacy perspective, although the substantive provisions of POPI are not yet in effect, every South African is afforded the right to privacy under both the common law and the Constitution. This right essentially encompasses the right to be free from intrusions and is based on the assumption that no one can unlawfully gain access to or put in the public domain information about a person which you reasonably regard as private. Like any other constitutional right, the right to privacy is not absolute, and it can be limited in accordance with Section 36 of the Constitution. Basically, what this means is that provided that the limitation is reasonable and justifiable in an open and democratic society which is based on human dignity, equality, and freedom, then it would be regarded as a justifiable limitation. So in this regard, only a law of general application could be effectively relied on by the state to limit the right to privacy. So the Disaster Management Act and the regulations would effectively constitute this law of general application, and the beneficial purpose of the law, which is effectively to counteract the spread of COVID-19, would need to be carefully balanced against the infringement to privacy. So to achieve this balance, the regulations contain various safeguards, which include, firstly, that no person is entitled to intercept the contents of any electronic communication. What this means is that the state won't be able to track the contents of our texts, our emails, and our social media communications. Secondly, the geolocation details to be obtained from electronic communication service providers may only be obtained for a specific period. And this period commences on the 5th of March 2020 and will terminate once the national disaster is terminated or lapses. The purpose is also very clearly defined, so the information may only be used or disclosed by authorized persons for the purposes of addressing, preventing, or combating the spread of COVID-19. Also, the Director General of Health must, within 6 weeks after the national state of disaster has been terminated, notify every person whose information has been obtained as a result of these regulations. So this means that if your location information has been obtained by the state under these regulations, you will be informed of this, and this is to prevent any secret surveillance under the guise of combating COVID-19. So will the government have the power to continue to track this data after the national disaster ends? And here the regulations are quite specific, and they provide that personal information may only be retained, apart from what is included in the database, for a period of 6 weeks, and thereafter it needs to be destroyed. Once the national disaster has lapsed or is terminated, all data subjects whose data was obtained under these regulations must be notified, and within 6 weeks, all the information must be de-identified or destroyed, and any de-identified information may only be used for research or study purposes. So accordingly, the state won't be granted these powers once the national disaster terminates. The intention of the regulations is really to take extraordinary measures to urgently combat the spread of the COVID-19 crisis, and post-termination, all such data will be de-identified or destroyed. So should we be concerned that our government might be spying on us? Again, the regulations are quite clear that these are extraordinary measures which are being taken to urgently combat the spread of the COVID-19 pandemic, and it's not intended to go further than this. So while an individual's privacy rights are being infringed here, the infringement is based on a lawful purpose in these specific circumstances. One of the safeguards which is in place in the regulations is the provision for a designated judge to monitor compliance and to make recommendations to government with regards to the best way to enforce these regulations. Once the COVID-19 disaster terminates, the state is required to file a report with the judge, setting out the steps that it's taken to destroy such information, and the judge may also issue further directions as to any further steps which must be taken. These measures will also be tabled in Parliament, and should the state continue to track data of individuals post-COVID-19 without a lawful purpose, then it would potentially constitute an infringement of privacy, and the individual would be able to bring an action against the state and potentially the electronic communication service provider for the infringement of their right to privacy, provided that they can prove that they've suffered damages. So what's important here is for us to continue to monitor how the regulations are implemented. The regulations give rise to complex privacy limitations, and as individuals, yes, we will be expected to give us aspects of our rights to privacy. However, this needs to be balanced against the current pandemic and also the purpose for which the regulations are trying to achieve, which is essentially to save the lives of South Africans. The regulator in the guidance note also noted that the government must still comply with all the applicable conditions for lawful processing as set out in the guidance note, and this would include the obligation to implement security safeguards. Given that all the data would be stored in a central database, one of the potential issues that this poses is that it might constitute a cybersecurity risk. So this brings us to our final topic, which is around cybersecurity concerns faced by business during COVID-19. Now, due to the nationwide lockdown, companies have had to very quickly transition to allow employees to work from home. Based on the President's speech last night, it's clear that remote working is going to be the new normal for the foreseeable future. And with an increased reliance on technology due to such remote working arrangements, your business may be faced with cybersecurity challenges, including cyber attacks and cyber-related fraud. So despite the fact that various cybersecurity software may be available to employees, there's an inherent risk in accessing a company's network from any other location other than the office. The most common forms of cyber attacks include the interception of email correspondence and phishing scams. And this often occurs when cyber criminals monitor the servers of either the sender or the recipient of an email and strategically intercept the communication by posing as a sender. Companies should also be aware that there's been an increased number of reported phishing scams related to COVID-19. So there's reports of fraudsters who are impersonating the World Health Organization, a company's HR department, or other government agencies, and enticing people to open up attachments or click on links with information regarding COVID-19, vaccines, or other investment opportunities. And then attackers are then able to push malware, ransomware, and gain access to personal information and passwords. So what is the law relating to cybercrime? Now, South Africa has a hybrid legal framework. Cybercrime offences are regulated under both the common law and various pieces of legislation. So email, interception, hacking, identity fraud, and computer-related extortion are recognized as offences under the Electronic Communications and Transactions Act. And here, the maximum penalty is a fine, which is unspecified, or imprisonment for a period of up to 12 months. The government also recently passed the Cyber Crimes Bill, which, once effective, will create a variety of new offences which currently do not exist under South African law, and will afford companies a greater degree of comfort relating to the prosecution of a cybercrime offence. Although South African law doesn't specifically impose cybersecurity or a duty to implement cybersecurity measures in an organisation, POPI does contain obligations on responsible parties to implement reasonable technical and organisational measures to safeguard personal information. And this will likely include adopting cybersecurity measures. So what safeguards can your business adopt to protect against these risks? I think here it's imperative for a business to review and adopt an information security policy which employees need to adhere to. Importantly, this must be communicated to your employees, and your employees should be trained and made aware of the risks. Employees should also be encouraged not to connect to unsecure or public Wi-Fi and utilize, where it's possible, VPNs to protect companies' proprietary information. Common sense should ultimately prevail here. So your employees should be checking URLs before clicking on any links and be aware of any suspicious emails. With the increased use of video conferencing facilities, employees should also ensure that meeting requests are legitimate and refrain from taking shortcuts, such as sending documents to colleagues on unsecured instant messaging services, or discussing confidential work matters on public platforms or public chats, and also avoid saving documents to their desktop as opposed to secure locations. Companies should also insist that any remote working arrangement should occur via its designated digital channels for remote working, such as VPNs or secure servers. So what happens if there's a data breach? Well, according to the latest annual cost of a data breach report, which was conducted by the Ponemon Institute, the average cost of a data breach in South Africa is approximately 43 million rand. And this is because the reputational damage and the effect that it has on the share price and shareholder confidence is often difficult to quantify and has a long-lasting effect. So as a result, remote working arrangements may pose a substantial and costly risk to employers from a cybersecurity perspective. If there is a breach, a business should make sure that they have a clear incident response plan in place. This should detail the process to deal with the breach, the notification procedures, who do you need to notify, who do you need to report to, and also business should be considering taking out comprehensive cyber insurance. So I think this concludes the speakers for today's webinar, and I'll now hand back to Christoph to conduct the Q&A.
Thank you, Fatima, and thank you to all the speakers. We certainly, you know, as lawyers have been and businesses have been bombarded with information, you know, about various measures, restrictions, and, you know, predictions as to what we can expect. And I think, you know, all the speakers did an excellent job at unpacking all that information. Attendees are still welcome to submit questions via the Q&A functionality, and some attendees' questions have been answered privately by individual speakers, but I will just select 2 or 3 questions and direct it at the relevant subject matter expert to deal with it. And the first question I want to direct at Mark Linnington, and it relates to the employee tax incentive, and the question is whether the increase of 750 Rand will be added on top of the existing limits, and how will the new age group, 18 to 29-year-old employees, be dealt with?
Thank you, Christoph. Yeah, the 750 is simply added to both the categories, the 1,500, the 1,000. The new category is simply 750 Rand per employee. And I actually neglected to mention another category which they've added, and that is employees who have gone past the 24 months and no longer qualify, and those employees are 18 to 29 years old. You can claim in respect of those employees as well, again, at 750 Rand per employee. So short answer, 750 across the board for each category.
Thank you, Mark. Then on the business interruption insurance, a question for Roy Barrense is whether an insurer can amend cover up to June, July 2020, and how one would deal with such communication. Roy?
Thank you, Christoph. The policies relating to the hotel, leisure and tourism industry normally run from month to month. In other words, premiums are paid on a monthly basis and cover is also then provided on a monthly basis. In most instances, there is a clause entitling the insurer to terminate cover for a particular type of risk on 30 days notice. I've encountered this on a few occasions recently. So where the policy authorizes the insurer to do this, then they may do so, but one should bear in mind that, and I think I've touched on it in my presentation, is where the horse has already bolted, you know, where the risk insured against materialized, the insurer cannot escape the obligation to indemnify for losses that arose out of those risks which already manifested. So on this scenario, if the notice terminates cover after, let's say, end of June, then only losses arising from COVID-19 that arise after say from 1 July onwards will then not be covered. I hope I answered that clearly.
Thank you, Roy. And then I'm going to just allow one more question, and this is for, I want to direct this at Clem Daniel, and the question is, if a business is not registered on an SMME database, will such business still be able to participate in these loan facility options that were announced?
Christoph, the position isn't clear to me at this point in time. I'm not absolutely certain, and we would have to dive into the detail of that. I'm unable to give you a clear answer on that right now, unfortunately.
Thank you. And then there was a question whether this webinar will be sent out. The answer to that is yes, it will, to attendees who RSVP'd to the invitation. The webinar will also be available on the CDH website, as well as on our social media accounts on LinkedIn and Facebook. If that is all the questions, I thank you for attending. Thanks again to all the speakers, and I want to wish each one of you all the best, and stay safe and healthy. Thank you very much.